Hi, welcome back, Attorney Steve Vondran. Welcome to another exciting episode of AI and the Law. This is the Mike Lindell case. You know him, MyPillow 2.0. Never slept better. All right, this is a case in the Colorado District Court. This is the 10th Circuit, Judge Nina Wang. This is a case where Mike Lindell accused Eric Coomer of some tampering in the election and affecting the outcome of the election. And he was sued by Eric Coomer, resulting in a $2.3 million judgment. That'll buy you a lot of pillows. But anyway, this case isn't about the defamation portion. This is about the defendants in this case. The law firm for the defendants submitted a brief based on AI citations and things like that. The court said, what the heck is going on here? You're submitting, as a matter of fact, let's just look right here. Let's go down in the opinion a little bit. The court says right here, there was all kinds of errors in the motion that the attorney submitted. And as they say here, misquoted cited cases, misrepresentations of principles of law associated with the cited cases, including discussions of legal principles that simply do not appear within such decisions, misstatements regarding whether case law originated from a binding authority, such as the United States Court of Appeal for the 10th Circuit, that would be binding on them, misattributions of case law to the district, and most egregiously, citation of two cases that do not exist. Can you imagine citing a federal court judge cases that don't even exist? I don't know if they were rushed to try to get this motion in, pulled up, I don't know if it was Grok, ChatGPT, or Claude, or whatnot, but they cited a bunch of cases that had a lot of violations here. Now, as practitioners, as a matter of fact, I'm going to read you this little exchange right here, which I found kind of interesting. So the court was asking, was this motion generated by AI? And the attorney said, well, not initially. Initially, I did an outline for myself, and I drafted a motion. Then we ran it through AI. Court says, did you double check any of these citations once it was run through AI? Well, Your Honor, I didn't personally check it. I'm responsible for it not being checked. And the court says, and you understand as an officer of the court, as lawyers are, pursuant to Rule 11, I did, Your Honor. If you're going to use, the court says, if you're going to use generative AI, that does not excuse you from the obligations of Rule 11. And I'm going to show you that in a second. Attorney says, absolutely not, absolutely not. You understand that, correct? Yes, Your Honor, I do. And that doesn't seem to have happened here, does it? No, Your Honor, no. So let's go look at Rule 11. This is something that every attorney needs to be aware of. Even unrepresented improper plaintiffs, pro se parties, are bound by Rule 11. So when you submit something to the court, you got to know that you've put some work into it and that what you're submitting has some legal basis. Here's Rule 11. Now, this is federal rules. Your state courts will have similar rules, but this is FRCP Rule 11. Here's what it says. By presenting to the court a pleading, a written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party certifies to the best of that person's knowledge, information, and belief, formed after an inquiry that's reasonable under the circumstances, the claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law. So, even if there's no legal precedent to help support your case, you can argue for a good faith extension or modification, reversal of existing law, or even new law. So that's kind of what we're looking at here. What else do we have? At Rule 11's core, an attorney who signs a legal document certifies they have read the document, have conducted a reasonable inquiry into the facts and the law, and are satisfied that the document is well grounded in both and is acting without any improper motive. So the court didn't like this. Court says here, this is even worse to me. The court has described respondent's submission of fake cases, that's what the court referred it to, as an unprecedented circumstance. A fake opinion is not existing law, And citation to a fake opinion does not provide a non-frivolous ground for extending, modifying, or reversing existing law or for establishing new law. So the court applied Rule 11 here. It says Rule 11 expressly provides that if, after notice and a reasonable opportunity to respond, the court determines that Rule 11B as in biscuit has been violated, the court may impose an appropriate sanction on any attorney, a law firm, or party that violated the rule or is responsible for the violation. So if your client just hammered you and said, well, you got to do this, well, maybe the party's going to be liable as well. Absent exceptional circumstances, a law firm must be held jointly responsible for a violation committed by its partner, associate, or employee. So if we go down here a little bit further, you'll see what the sanction was. There it is, conclusion. For the reasons it is ordered, the court hereby sanctions $3,000 joint and severally. The court hereby sanctions $3,000. So there you have it, due and payable to the Registry of the United States District Court, District Colorado, no later than August 4th, 2025. So guys, AI is a great tool. It's a great tool to have in your toolbox. I use it all the time, but it's not quite 1,000% ready as it would need to be. You need to check your citations. You need to check the references being made. You need to check the arguments that Grok or ChatGPT, they're telling you this is the summary of the case. You need to check. It's not quite there yet, with all due respect to their wonderful platforms. So.